Our next speaker is Yvonne Donders, who is a professor of international human rights and cultural diversity at the University of Amsterdam. And Yvonne's talk, the title of her talk is The Recommendation as an International Legal Instrument, Possibilities and Pitfalls. So please, Yvonne.
Thank you very much. And again, a pleasure to be amongst you and share some of my thoughts. And actually my talk indeed very well connects to Sebastian's, in the sense what I would like to speak about today is to place this recommendation in the broad field of international law. So what does it mean, such a recommendation in legal terms? And also hopefully answer a bit your question, Helle, to Sebastian about what do you see as the importance or unimportance of this recommendation. I will also share my screen with you in terms of looking at my presentation. There we go. So because the recommendation, as I just already said, is of course a document, an instrument, but it's first and foremost also a legal instrument. And what does that mean? And a bit about how and why it was adopted and why within UNESCO, and what does it mean to be this legal instrument? And what we always do when we have these recommendations or other legal instruments, we particularly as lawyers and also with the students, we tend to tear these documents apart. We look at each and every provision and word and comma, and we wonder sometimes, why is that in there, why not that? Or as Sebastian was already pointing out, why is there controversies in there or contradictions even between different provisions? And that leads us, I think, to some form of a reality check, in the sense of what we might think are documents that are well drafted in a nice way with a good negotiation. Well, actually, sometimes there's a lot in there, not so much for legal reasons, but for political reasons. There's a lot of coincidence, whereby some things end up in there and others don't. Commas are placed where they should not have been, etc., etc. And so therefore, I always tell the students, at least, and here also to you, we have to take these documents indeed in their context and not perhaps always look at them too literally, because, yeah, well, things happen to be in there or happen not to be in there. Another connotation with these legal instruments is that, of course, they're drafted by states, and also within these different organizations, different documents are drafted. And the reality tells us that, for instance, in UNESCO, they're mostly drafted by people involved in education, culture, and science, and also people from ministries in those elements, in those kind of aspects. Whereas in other fields, in other parts of the United Nations system, such as in Geneva, New York, they're sometimes drafted by different ministries or with different emphasis. Maybe the Ministry of Economics or Finance are more involved, or maybe the Ministries of Foreign Affairs. And what you see when you participate in these kind of negotiations is that you very often see that that matters quite a bit, which kind of ministries are behind a certain document. So that is a bit of the background of my talk. So as we said, public international law, first and foremost, it's created between, by, and for states. And that does matter because they are the ones driving the process. And they do that from the idea of state sovereignty, of equal states that actually together draft these documents. And particularly in UNESCO, of course, there's different powers in UNESCO between different states, but in the end, they all sort of have a voice in there. So powerful states, larger states, smaller states, etc. And the sources thereby of these obligations are indeed the idea that states voluntarily consent to these obligations. And they can also decide not to. So they decide, for instance, what the form of the document will get, and also what will be in there, but also in the end, to what extent they adhere to it. And for instance, with this recommendation, I wasn't sure, because I wasn't directly part of it, to what extent other than states have participated in the drafting. I know that national commissions for UNESCO have been consulted, perhaps others have been consulted, but in the end, it's in the general conference of UNESCO, so it's states drafting this thing together. And a bit about public international law, this may sound familiar to you, but just to place this document once again in the broader spectrum of public international law. So the sources of international law are broadly divided into hard law and soft law instruments. And hard law is binding after at least a state has ratified it. And again, a state can also decide not to ratify a treaty, not to become a party to that treaty. And those are indeed the treaties, the conventions, the covenants. They have different names, but it's the bindingness and the consent of states to be bound that are central to hard law. Then we have these soft law instruments, which are not legally binding at least, and those take the form of declarations and such as these recommendations. Now, if you look at the content of these instruments, they can be more about a traditional contract between states at the horizontal level, whereby states agree to have mutual rights and obligations. And that is to be distinguished from what we would call more normative instruments that, of course, are also a contract in a way, but that do not so much create mutual obligations, but obligations towards others. For instance, human rights instruments are more normative instruments. It's not so much about the agreement between the states on the obligations between them, but much more about the obligations that these instruments create for states towards, in this case, individuals or communities. And if you look at this particular recommendation, it's of course a soft law instrument, but it is a bit in between the contract, but it also contains some of these normative elements. Now, the subjects, therefore, of international law are first and foremost states. They agree on whatever they want to agree. And this creates a form of reciprocity. It creates the idea that we have an agreement together and that we all respect that agreement. And if we don't, or if one of the parties doesn't, then the other parties can take certain countermeasures, for instance. Or they can even say, well, this contract is ending, just as we have contracts in private law. If I rent an apartment from an owner, then I have a contract. If I don't pay my rent, I don't respect my part of the deal, then the owner might say, hey, I kick you out, or I take other measures, because I also then I'm not obliged to respect my part of the deal. Now, of course, again, with these normative instruments, that reciprocity is less relevant, is less important, because actually it's not so much about what states agree inter se, but it's much more about the obligations they have towards other subjects, namely individuals, communities, or organizations. And therefore, if one state doesn't respect the part of the deal, you really don't want the others to do the same. You really don't want other states to then say, well, then I might also just as well not respect my human rights obligations because other states don't do it. And that creates a tension between states, but also for individuals, in the sense of that they might say, well, you still have obligations towards me, even though others might not exactly respect the same agreement. Now let us look at the idea of where this recommendation comes from, and it's superseding, as Helle was already indicating, an earlier recommendation on science, which was already adopted in 1974. And this is part of why this is within UNESCO, is because of the mandate, of course. Now, UNESCO's mandate is broadly this: to promote peace through collaboration among nations, through education, science, and culture. So indeed, what UNESCO stands for is this collaboration, this cooperation between states in these areas, but all in the idea to promote peace, to promote prosperity, to promote well-being for people. So, of course, UNESCO is active in the field of science, and therefore a recommendation such as this is very well placed within UNESCO. At the same time, it doesn't live in a vacuum. These international instruments are all to be seen as part of international law, and thereby part of a broader spectrum of different international instruments. And of course, the most important instruments that we address in relation to science and scientific freedom are the Universal Declaration of Human Rights and the Covenant on Economic, Social, and Cultural Rights, which indeed both include this right to science. So in my view, what we should see is that whatever UNESCO does should also be in relation to these instruments. And UNESCO has been actually at the forefront of both. UNESCO was the one proposing these kind of rights in these international instruments. So you see the role of UNESCO was to claim this idea of the right to science within the United Nations system, and it continuously works on it. So if we briefly first look at the recommendation of 1974, it was mostly based on these three core elements. The idea that science was not only a positive thing, but that science could also do a lot of harm. So the idea of science that should be for the benefit of people and not cause harm was very present. Secondly, indeed, inspired, of course, by the Universal Declaration, by the Covenant on Economic, Social, and Cultural Rights, sharing of benefits was another core element. So that the idea was that several states where science was flourishing should also share that with other countries, but also in their own countries, many people should be able to share in the benefits of science. And finally, and already mentioned several times, international cooperation in the field of science was also considered to be crucial. But what you see in this recommendation is that indeed there was a wide margin of discretion for states. So it's always the case with international law that in the end states adopt it at international level, but they're supposed to implement that also at national level in their national laws, their national policies. But you see in this recommendation clearly recognize that states have quite a wide margin of discretion, as we call it, which means they can choose the means, they can choose whichever laws they want to adjust, they can take space in their policies to implement this recommendation the way they see best. Now that, of course, on the one hand creates flexibility, creates perhaps a broader respect for these recommendations and these instruments. But on the other hand, it creates also a form of diversity, a form of diverse interpretation and diverse implementation of these recommendations. And again, that can be sometimes seen as positive, but it can also mean that it might lead to different implementation, whereby individuals, communities, scientists have different rights in the end based on these instruments in different countries. Now, why would this recommendation be revised? Because of course, we had this recommendation, so why did states decide to revise it? And I think that was done, if you read the UNESCO documents, because states did realize that the world has changed, obviously, since 1974, in particular in the field of science as well. And Sebastian alluded also already to that. So for a long time, states have been proposing to see if this recommendation could be revised. Now, several countries, amongst which my own, the Netherlands, were very much against such a revision, not because the country didn't realize that the world had changed and that science took a different position in societies, but they were afraid that actually this would bring indeed also the possibility that certain states might push for perhaps a different form of scientific control, and that would be part of this recommendation. So the Netherlands, but several other countries as well, were actually quite hesitant to adopt a revised version. And this, of course, should also be seen in light of the dynamics within UNESCO. Now, UNESCO is a worldwide organization. Many states are members of UNESCO, but one of the states that is no longer a member state of UNESCO is, of course, the United States. So the United States had withdrawn from UNESCO before, re-entered the organization in 2003, but then again stepped away from it. Not so much because of this particular recommendation, but because of many of these instruments where the US found that UNESCO was not doing a proper job, and therefore they stepped out of the organization. Now, what that means is, of course, quite serious, that one of the most powerful countries in the world does not actively take part in some of these negotiations, or they do, but then via other states. You see that still the US is a powerful player in UNESCO, even though it's not a formal member state. And you see, therefore, these dynamics also reflected in the adoption of these kind of recommendations. I'm actually not sure that would the US have been a member state completely, fully of UNESCO, that this recommendation would have been revised and adopted as it is. So again, there's positive and negative elements to that. Now, the revised recommendation indeed includes new issues, new elements that it addresses. First of all, the much more internationalization of science, the mobility of scientists that do not only work within their own university or their own country, but now really, as we do all, work across borders and establish contacts and alliances with scientists all over the globe. It also implies that we share indeed a lot of our work much more broadly. Although I always have to make the connotation that there's still, I think, a lot of divide between, say, the Anglophone scientific community and several of the other language communities, scientific communities, that we hardly have contacts with, or that we have a hard time collaborating with because they publish in, say, Chinese or Spanish or French or languages that not everybody is perhaps so familiar with. And it works, of course, both ways. We would like people to participate, but it's hard if you don't use the same language. Other new issues, of course, security, environmental concerns that were brought to the table, security concerns in terms of the dual use and what was already mentioned, environmental concerns that should be taken into account. Also very present indeed in this document is the role of the private sector, not only as related to intellectual property, but also as related to the funding and also the ownership of much of the scientific data, the scientific research is now no longer in the hands of states. And this is indeed a major shift, also if you look at international law, because international law, as I said, is created by, for states, whereas in particular in human rights and the right to science as a good example, you may wonder to what extent states can actually live up to their obligations if some of the, well, elements are not in their own hands. If funding is, for instance, much more provided nowadays by private donors or private companies, and also whereby the research that is done and the data is not in the hands of states. So that creates already a tension that these kind of international instruments cannot really tackle very well. Then there's a lot on the ethical aspects of science and on interdisciplinarity. Indeed, in this particular recommendation, the also maybe softer sciences such as social and human sciences are more recognized and more present. And this has led, in my view, positively also to the realization that indeed this link with human rights should be strengthened. And you see it throughout the text referred to, at least, even though I agree with Sebastian that not all the human rights aspects, such as scientific freedom, are sufficiently addressed. But the link with human rights is strengthened. And again, it's at least recognized that this recommendation should be read in context with, for instance, human rights instruments. And why that is also important is that a human rights approach to science has several advantages, several necessities even in my view. And that is that it's about rights and obligations. It's not about charity, it's not about being nice to one another, it's really about individuals, communities having rights, and it's also about states and perhaps also other actors having concrete obligations. Another important aspect of the human rights approach is the attention, the needed, necessary attention for disadvantaged groups, such as women, children, elderly minorities, indigenous peoples, but also very importantly, people with disabilities. And I'm sure that will be discussed later on as well. What UNESCO also wanted to do with this instrument is indeed put that into the new policy documents, new policy frameworks that we have, such as the Sustainable Development Goals and Agenda 2030. And as Helle already elaborated, recognition of science as a common good is, in my view, a very good starting point in this particular recommendation. Now, reading all these documents in their context and in their linkages, again, has of course the advantage that you see them as a comprehensive whole, but it also may lead to a form of cherry picking. And you see that, in my view, in particular, sometimes with the SDGs. Nowadays, states tend to be focusing a lot on the SDGs and on their goals that they have there and on the things that they do to achieve those goals. But we should not let the attention slip away from the already established human rights obligations that states also have. Because as we know, the Sustainable Development Goals and Agenda 2030 set a stage which is much more a goal. It's much more a perspective whereby states do not have concrete legal obligations. And again, for me, it's important always to emphasize that yes, the SDGs are important, but underneath there, or as an important part of that, is human rights instruments that create concrete legal obligations as well. Now, in my view, some of the positive elements of this recommendation are the definitions of science and scientists and scientific researchers. Now, of course, one may debate whether this is the perfect definition, whether the definition is sufficiently covering everything. For instance, in science, I think one of the issues a bit missing is traditional knowledge, or how that would be or wouldn't be included in the issue of science. And this is also a debate in the human rights context, whereby, for instance, under the covenant, it's now recognized that traditional knowledge should at least also be part of science. However, what these definitions at least do is that they create some form of agreement between states on these important issues. And now they're laid down in an international legal document. So at least they have a certain value that we should be able to work with. Secondly, and a new element added to the elements of the 74 recommendation, is the whole debate on science-based policymaking. I think a very important issue that we see that is absolutely needed nowadays, but it's one of the things that was put in the recommendation, that scientists and scientific researchers play an important role to provide policy makers with facts, with analysis that they should be using in deciding on policies. And furthermore, what surprised me positively actually is that the language of this recommendation is much more obligatory than I would have expected. You see in the document constantly that member states should do something, should take measures, should take certain activities or actions. And it's not therefore a completely voluntary exercise whereby they may decide what they want to do. They are at least obliged to do something. And as Sebastian was already indicating, it's a very detailed text with many provisions, many different aspects of science and scientific researchers, such as on health, on training, on education, also on mobility, on work perspectives, etc. So those, in my view, are quite a few important elements that this recommendation provides us. But of course, it's not all a rosy picture. There are also, in my view, many challenges in this recommendation. First of all, that this recommendation does indeed not provide substantial human rights for individuals or communities in terms of scientists, but also in terms of the general public, or indeed indigenous peoples or other communities. It doesn't provide such substantial rights. Now, of course, you may say it's not needed because we have those in the human rights instruments, but it would have been strengthening if the recommendation would not only be addressed to states, but it would also create a form of substantial rights for individuals and communities that they could invoke somewhere, that they could use in front of a court or a monitoring body, for instance. But if you look at the text carefully, that is really not what the recommendation was meant to be. Then again, what is still there is that implementation at the national level leaves a wide margin of discretion to states. I've already told that this has positive and negative sides, but it might lead to a sort of watering down of the whole idea, whereby states say, yes, I'm trying, I'm taking certain measures, but whether those completely comply with this document is not very clear. Also, because this document is a recommendation, it's an advice to states how to behave, but it doesn't create legal obligations for them. So of course it fits that there's not too much detail in this document, but I agree with Sebastian that that could also lead to, well, states saying, well, I'm not sure what to do, I'm doing something. In my view, that is enough. Now that leads me to another, in my view, weak point, and that is the monitoring. Monitoring of these international instruments is very important because otherwise they do remain purely a legal text that nobody can actually say, does it really make any difference? Does it lead to changes in policies, in laws, etc.? Normally we have a lot of monitoring bodies. For instance, in the human rights sphere, we have each and every treaty has an independent monitoring body. can be a committee, can be a court. Here in this document, again, understandable because it's a recommendation, but the monitoring is quite weak and is completely interstate. It's states judging upon each other. It's, as Helle was alluding in the document itself, it said, well, let's see how we do the monitoring. It's not even included in the document itself. But more recently, UNESCO has picked it up and said, let's organize the monitoring. And it's now composed of a 4-year cycle of reporting. So states report themselves to the General Conference of UNESCO how they've implemented this recommendation. Now, unfortunately, what we see in UNESCO generally is that the reporting is not very well done. Many states never report at all to UNESCO about how they implement these kind of recommendations, but also all of the other treaties and instruments that are adopted within UNESCO. The monitoring thereby is very weak because if not a lot of states report, first of all, it might lead to other states saying, well, if many don't do it, why would I do the effort? Moreover, if only a few states report and those reports are discussed by the General Assembly, it seems that only those states are put on the spot. So therefore, it would be better if the monitoring would be by some kind of an independent body, if that would be set up, but also that states are much more encouraged to report. Now, of course, I realize that this reporting is a burden upon many states, because the whole United Nations human rights spectrum is full of reporting procedures. We have for each and every human rights treaty, you have to provide reports regularly. You have the Universal Periodic Review in the Human Rights Council, whereby states also every 4 or 5 years have to report on their human rights situation. And now also UNESCO is demanding these kind of reports, not only for this recommendation, but also, for instance, for all the cultural heritage treaties. So many states say, well, you know, I'm a bureaucratic system, but this is overburdening me. I cannot report constantly on each and every recommendation, every instrument that I'm having obligations under. So this is indeed a problem. And therefore, what maybe in the meantime, before we can get to some kind of a real monitoring, I would like to propose several things that we can actually do with this recommendation. So first of all, I think the recommendation deserves, because it is a good document with a lot of good elements, to be known by the people who might be implied in it. So first of all, I think it's up to all of us to raise awareness about this recommendation, because I'm sure that not many scientists, scientific organizations, institutions, NGOs, but also others know about this recommendation. So that's, I think, the first thing we may want to do. A second thing, as I said, is to promote the reporting in UNESCO in cooperation with national commissions for UNESCO, but also to involve actively other stakeholders in this reporting and to try to convince states to at least provide, even if it's a selective part, but to provide some information on how they implement this recommendation. Because by showing what they have done, they can show how they consider it an important issue. But this perhaps should be done not only on this recommendation per se, but I would also be already very happy if this recommendation would be taken up in reporting in other processes. So when states report to human rights treaties, or when they have to report on the SDGs, which they also regularly have to do, then it would be great if they could include that they do this, have changed these laws, have changed these policies, partially also in light of this particular recommendation. Sometimes it's better if you link all these things. We do that now for the SDGs and human rights treaties, vice versa, but perhaps also this recommendation could play an important role in this. So to wrap up, I think the recommendation has, of course, its possibilities and its pitfalls. First of all, because it's a recommendation and not a legally binding instrument. And of course, that creates the issue that states have a leeway to implement this the way they see best. At the same time, the fact that they have talked about this recommendation, have negotiated it, and have in the end come to a concluded text shows us that it does maybe not have legally binding force, but it must have political and normative binding force in the sense of that states should take it seriously. In the recommendation itself, important new aspects of science have been addressed. And also the recognition of science as a common good is, in my view, certainly a step in the right direction. But then again, it's in the end all about what we do with these kind of things. And that, in my view, hopefully, is not only a matter of states and governments and local governments at each and every level, but this is also a matter of what we do with it. NGOs, scientists, scientific communities, why don't we try indeed to pick up this document, and perhaps not on the whole document, but pick out certain issues where we say, let's discuss this further, and let's thereby tell our states that they should respect the concrete issues in this recommendation. I think only by doing this also from the bottom up, we can make this recommendation a much more valuable document than it may seem on paper. And with this, I thank you very much for your attention.